Hi, my name is Carl Pearson, and I have this video number 47, Sue the Banks to Quiet Title while they're in disarray. My name, as I've said, is Carl Pearson, and I'm an attorney defending against foreclosures, and I want to tell you something about many financially troubled homeowners and what they should do to get a loan modification agreement. They should sue the banks while the banks are in disarray and reeling from the recent adverse decisions and court rules across the country. Now let me tell you why you may have a better chance to obtain a loan modification agreement if you sue. First, the banks don't want to give you a loan modification agreement, and when they ask for an application and then they lose it and they ask again and a third and a fourth and a fifth time, and they do it for millions of people, it's no mistake. They don't want to give a modification agreement. They're horsing you around, and they're on a dual track system because in many cases they have a foreclosure action pending. So they pretend that they're interested in giving you a loan modification agreement, which they are not. They're pursuing a foreclosure action, and by your inattention to it and thinking that possibly you'll get the loan modification agreement, you're not defending the foreclosure action in those judicial foreclosure states. Of course, in the non-judicial states it doesn't work that way. There's no foreclosure action. They just sell your property. So the banks are reeling now. They are in disarray, and they have trillions of dollars of their assets at stake. Their real estate assets, the securitization of these mortgages, trillions of dollars. And these recent decisions are one in the highest court in Massachusetts, the Ibanez decision, a San Diego bankruptcy court, a New Jersey bankruptcy court, Judge Boyko in the Ohio Federal District Court, the Supreme Court of Kansas about MERS having no standing, the Supreme Court in Suffolk County, New York, a Judge Spinner, who, by the way, was reversed, but there is still opportunity in what he said for, if you'll read his decision, and the Supreme Court Nassau County Judge Shack. There are a growing number of doctrine and cases which are favorable to the homeowners, that give you some opportunity to fight back. But you really can only fight back in court. There's, in addition to all this, the robo-signing of foreclosure affidavits and applications, false notarizations, people that aren't members of MERS signing documents as if they were officials of MERS, not complying with the rules and the laws relating to foreclosures, and that's as to millions of foreclosures. So the banks are reeling now. They don't know what to do. And they have, in addition, the New York court on October 20, 2010, possibly because of something that I had done when I was running for Attorney General in New York, require an affidavit of compliance, and that is something which is difficult when you don't have the note and mortgage. So there's also these other considerations, and that is that the banks are holding too many unsold properties now, or potentially through foreclosure and sale. They may have burned the original note and original mortgage. They may not be able to find the original note or mortgage even if they didn't burn it. They may have a title problem relating to MERS and the securitization of your mortgage. The securitization of mortgages, as done, might be a violation of federal and state securities laws for non-disclosure, and may give you some kind of defense for being involved and being injured by it, by an illegal practice such as that. And the banks and its attorneys may have committed foreclosure fraud, and the bank may not be able to get title insurance, which reduces the bank's recovery upon sale of the property in a foreclosure proceeding. So, although the banks are probably not going to enter into class action driven loan modification agreements across the board, which would destroy trillions of dollars in asset value for the banks are more willing to enter into a loan modification agreement to settle a lawsuit with a specific individual. If the homeowner is in court, and if he or she shows that he's financially able to pay the lower mortgage payments. That's an important aspect of obtaining a loan modification agreement. Also, you have to be living in the property. I have to state that so we're clear on that. So if you are in financial trouble and need a loan modification agreement, and you are getting nowhere with the bank, which usually doesn't want to give a loan modification agreement, and they put millions of troubled mortgages through hell with requests for duplicate applications and only to deny these requests, that there is something that you can do, and that is you sue the bank and its predecessors, alleging on information and belief with appropriate facts from what we already publicly know, that the bank and its predecessors and the investors have no legal interest in your property, and you ask the court to declare such in an action to quiet title. Actually, the banks in Massachusetts asked for a quiet title so that they wanted the court to hold that they owned the property after selling it, and the highest court in Massachusetts said, no, we're not going to give you a quiet title because you didn't comply with the rules. So here is another aspect of this. It would be best if you could continue paying your mortgage payments during this litigation period until you get an LMA, a loan modification agreement, in which case the litigation is over. And that would prevent the bank from countersuing you in an action or a counteraction for foreclosure. And then there is the ever-present problem that sometimes banks will not grant a loan modification agreement unless you are behind in your payments and vulnerable to a foreclosure, which is the sickness and the fraudulent aspect of what they're doing, is that they don't allow you to even apply for a loan modification agreement unless they have a right to sell your property out from under you. And then they don't give you the damn loan modification agreement, which is what they planned in the first place. So let's wake up. You have to go into court and exercise your rights in order to get what you need here. So if you can't afford to make the payments to the bank, you still can sue the bank, but as I've said, the risks are different because the bank will come back with a foreclosure action, which of course is what you want in a judicial foreclosure state, because that's where you get into court for the first time. But the purpose of the suit is to get the bank to give you a loan modification agreement and have you execute a new original note and mortgage, which the bank this time will keep in a safe and a retrievable place if it has to sue you at some later date for non-payment of this new mortgage. Also, the bank will ask you to waive all of the legal issues that you raise against the bank. You get a loan modification agreement, and the bank gets to clear up its rights as a mortgagee. A good deal for both, by the way. But you probably will have to be in litigation against the bank to get this relief. In a judicial foreclosure state, you could assert this claim or series of claims as defenses and counterclaims after the bank starts a foreclosure action against you. But in the 27 non-judicial states, you never get into court unless you commence the action. So this is what you can do. If you have any questions, please give me a call. My telephone number in New York is 212-307-4444. I provide free consultations by telephone, and I can represent homeowners in any courts in the U.S. through use of local counsel and a pro hoc vici application to represent you in the courts in your state. My telephone number again, 212-307-4444. Please give me a call. Thank you.